Give this a whirl. I know it's not perfect, but here we go. I'm here today to give you the decision on the Martin versus Lexus of Milwaukee, or Napleton Lexus of Milwaukee. Some of you have been watching that hearing. This is the hearing where the salesperson complained about wages, and it, according to everybody's testimony, so did a lot of other people. And he, shortly after he complained about his wages and not being paid appropriately and all of the mistakes that were constantly being made with pay for him and others, they terminated him. And not only did they terminate him, but they also accused him of doing something illegal in the car industry called curbing. So we have the decision, which hopefully you can see up on the screen, and I'm going to take us through the decision so we can find out how this played out. And so when you get a decision from the Equal Rights Department, it comes like this. And I'm not going to go over all of these beginning parts because many of us who watched the video know all of these pieces. There's a findings of fact section where the ALJ writes out their, I guess from the notes they take, what they determined as to be the facts. I mean, I hope these judges go back and listen at least to the recordings, because unless they are taking some pretty good darn notes, I don't know how they come up with that. Then they come up with conclusions of law. And so here we see, basically they can say he was an employee of Lexus. He was the Lexus of Milwaukee is an employer in purposes of the Wisconsin Fair Employment Act. He filed a written complaint on August 17th, 2018, and he tried to enforce a right. And then Napleton Lexus of Milwaukee discharged Malcolm for attempting to enforce his right under Wisconsin Stat 109.03, which is a violation of Wisconsin Stat 111.3222M. And then he says this was one reason. Yeah, it's the illegal reason among several for Malcolm's discharge. So here he grants him the win, but also says you got fired for your own fault. So let's see what the order says. The respondent shall cease and desist from discriminating against a complainant on the basis of his complaint. Well, besides the words on this page, that might as well not even exist. The respondent shall pay the complainant's reasonable attorney's fees and costs incurred in pursuing this matter in the amount of $59,437.50. So this employee had to, pay this attorney. And by the way, she was a boss attorney. Boy, was she really good at getting to the brass tacks of what happened in this case. And she really questioned witnesses with some very good direct as well as cross. And so the attorney is going to get this check for almost $60,000. That's what he won. He won payment for all of this garbage. Within 30 days of the date on which this order becomes final, the respondent shall file with the Equal Rights Division, attention, compliance officer Amanda Tolfinson, a compliance report detailing the specific actions taken to comply with this order. The compliance report shall be prepared using the compliance report which has been provided with this decision. We're going to take a look at that. The respondent shall provide a copy of the compliance report or complaint at the same time that is submitted. Within 10 days from the date that the compliance report is served on the Equal Rights Division, the complaint shall file the Equal Rights Division and serve on the respondent a response to the compliance report. So basically, what this employee won as a result of being discriminated against was he won his lawyer's fees, and he won a letter saying, we're not going to do this again. That's what he won. Okay, so this was April 8th, 2022. and it was signed by John Gelhardt, the administrative law judge. So here they cite the statutes that I mentioned earlier. Discriminatory actions prohibited. Gosh, my tongue-tied. Discriminatory actions prohibited. And so he's citing this. When wages payable, pay order. I don't think he gets any wages from this. So here's Napleton's decision to terminate Malcolm Martin. And I guess this is where I'm trying to think where we want to. I'm not going to replay this because we heard this. I do want to go down to. Oh, yeah, I do want to read that part. Or some of it. Basically, when Malcolm filed this about his right to compensation, this boss said it is the worst complaint he had seen in a while, and he knew things were going down a bad road. Yeah, basically you knew you were being called out for violating somebody's rights. And he felt threatened by the letter. He felt threatened that somebody took a formal action to say you're violating my rights. Then they tried to get him, Martin remember this? They tried to get him to sign a letter saying, you owe us money as an employee here. You owe us $4,000. The respondent makes light of the fact that the Wisconsin Wage and Hour Division determined that Napleton only owed Malcolm Martin $76,012. So really, when they were trying to convince him to say, you owe me $4,000, they actually owed him money. Malcolm Martin did not owe Napleton any money. Malcolm Martin was discharged. And in order to establish a prima facie case of retaliation, the employee must show that he opposed an unlawful employment practice, he suffered an adverse employment action, and that there was a causal connection between the opposition of the adverse action. Now, here's some great citations here. There was an extremely short period of time between the August 17th letter threatening to take his case to the Wisconsin state authorities because his pay was shorted and the discharge on August 29th. Yeah, I'd say. Coupled with John Friedel's overly negative reaction to receiving the August 17th letter, it must be concluded that the complainant's decision to invoke his right to seek what he believed was his correct pay, and actually was a factor in the respondent's decision to terminate his employment. Now, here's the interesting part. This is where the ALJ goes on to basically say all the things that he feels Martin did to deserve a termination. Now, even though he just said that this happened and then this happened, he still feels that it is acceptable for the employer to go back and cite any past perceived wrongdoing that this complainant did. I didn't see any evidence of him doing that. I heard the bosses trying to say that after the fact, but I didn't see any of that actually happen. So let's go into this. During the course of the ERD investigation, the reason for the discharge was once again as attitude towards managers and curbing cars. Okay, this was that again illegal thing that they threatened Martin with. At the hearing, John Friedel testified that the sole reason for the discharge was Malcolm Martin's outburst and threat of physical violence on August 29th, 2018. The respondents' different explanations for the discharge suggest an attempt to shift the focus of the discharge from the discriminatory reason for the discharge. When a company at times gives different and arguably inconsistent explanation, a jury may infer that the articulated reasons are pretextual. That is your key right there. And if you are having this, you're going to want to keep these citations for your own writings. So here they talk about Malcolm Martin's altercation with John